Hello and welcome to Chapter 4. Now we're moving away from contract law now. We're going to look at tort law. Now tort is defined as a civil wrong, and you can bring a claim in tort where you've suffered some sort of damage or harm, but you had no pre-existing contractual relationship with the person who caused you that harm or loss. We see there's lots of torts that we're aware of, probably in everyday language. The tort of assault, false imprisonment, trespass, nuisance. Remember, we're still in civil law here. This isn't the crime of assault. This is somebody claiming damages for harm that they've suffered. Now, unlike contract law, where the purpose of damages was to put you in the position as if the contract had been performed, damages in tort are slightly less preferable because they aim to put you in the position as if the tort had not happened. There's a limitation period, just the same as there is for contract law. It's 6 years, but for most claims anyway. But the limitation period in tort runs from the date of the tortuous act, the date that you suffered the harm. In contract law, they run from the date of the breach of contract. Note that 6-year time limit is reduced to 3 if it's a claim for personal injury. Now, I've got an example here just to give you some context. So David is hired as a chauffeur working for Estelle. And he drives the car, drink driving, crashes it, runs over Ewan and injures him, and also injures Estelle. So we're asked to think about what legal disputes could arise. Well, clearly, David is going to have committed some crime, dangerous driving, reckless driving, driving under the influence. But also, he's going to have breached his contract with Estelle because there would be, at the very least, an implied term in that contract with Estelle that he would carry out his duties properly and certainly wouldn't be driving whilst he was under the influence of alcohol. So Estelle may be able to sue for breach of contract, but Ewan has no prior legal relationship with David. Therefore, he couldn't sue under contract law. The criminal proceedings aren't going to help Ewan to pay for his hospital bills and so on. So his cause of action would be to sue for negligence under the principles under tort law. Estelle could also claim under tort if she wanted to, so she has a choice whether to sue for negligence or sue for breach of contract. Now, if we want to establish the tort of negligence, what do we need to have? Well, this little diagram here just shows you the building blocks, if you like, of tort law, and it's up to the claimant to show all of these first 3. Okay, the person bringing the cause of action. So first of all, he has to show that he was owed a duty of care, that the duty of care was breached, so the standard offered wasn't high enough, and that as a result of that, he suffered some sort of loss or damage. So first of all, who do you owe a duty of care to? Well, remember, you don't need a contractual relationship here. The lead case is one called Donahue v. Stevenson, and this is back in 1932. And in this case, the claimant was bought a bottle of ginger beer. Her colleague actually went to the bar and bought it for her. So in terms of contract law, the contract would have been between the claimant's friend and the bar. So that wasn't going to give them a cause of action here. The claimant then drank the ginger beer, and you know the thing with ginger beer is it comes in like a brown bottle, so you can't see inside it. So she tipped half of it into a glass and drank that, and then tipped out the dregs into her glass as a sort of second helping, and at that point found half a decomposed snail in her drink. So the only thing worse than finding a decomposed snail in your drink is half a decomposed snail, because you have to wonder where the other half might have gone. So the claimant was very ill as a result of drinking this contaminated ginger beer and wanted to claim damages. Obviously, she couldn't sue the barman because she hadn't bought the drink. That wasn't where the contract lay. So she decided to sue the manufacturers of the ginger beer. And the court agreed with her. They said even though there was no contract here, the manufacturers of the ginger beer owed a duty of care to any customer who would drink that drink. And what they said was this was the principle of the neighbour principle. And they said you owe a duty of care to anyone who is so closely and directly affected by your actions that you ought reasonably to have them in your contemplation. So put into plain English, if it's obvious that someone would be affected by your negligent action, you owe them a duty of care. So that was the landmark case. Now, since then, the courts have looked at the cases in a little bit more detail, and they have restricted the situation when you might owe a duty of care a little bit. And there are now 4 tests that you need to be aware of, and these came from something called the Bishop's Rock Marine case. So the first thing is, it must be reasonably foreseeable that somebody would suffer damage as a result of your negligent act or omission. So, a normal person, a reasonable person would have realised that somebody could be injured or somebody could suffer harm as a result of the action. There needs to be something called proximity. Now, that's not just physical proximity. It could be sort of legal proximity. You'll see it defined there as neighbourhood between parties. So there has to be some sort of relationship there. And there's a fairness test. Is it fair, just and reasonable to make the defendant liable in this situation? And then the final point is a public policy test. Would the decision offend public policy? So the courts don't want to set up a doctrine allowing people to sue defendants in a situation that really would be against public policy. Now, having established that you are owed a duty of care, you now have to show that that duty of care was broken, that it was breached in some way. So let's start by looking at the standard of care that's required here. And again, the courts have got that reasonable man out again. The reasonable man guided upon those considerations which ordinarily regulate the conduct of human affairs. So what they're saying is, would a reasonable man have behaved in the way that the defendant behaved? So what the court have said is, if you have a particular skill, then you must use it. So, for instance, you guys, once you are qualified accountants, are expected to demonstrate the skill of a qualified accountant, and that kind of raises the expectations of you. It raises the bar slightly. However, whilst you're a trainee, the bar is not lowered. The fact that you don't have any skill doesn't make it any more acceptable for you to behave negligently. So, for instance, a learner driver owes the same duty of care as a qualified person would, a qualified driver would. And similarly, as trainee accountants, you owe the same duty of care as a qualified accountant would. Now, this next point, there's no hindsight. So this is particularly important with things like medical care, where medical knowledge is advancing all the time. If your doctor treats you in a way which is consistent with knowledge and practice at that date, if you find out 6 months later that we now know that, that medical treatment was completely inappropriate and in fact actually made you worse, you can't sue that doctor because he was doing the best he could based on what was known at that time. Also, body of professional opinion. If you are following the professional body's recommendations at a given time, then you can't be treated as being negligent. But be careful with that, because this isn't, what does your friend, also a doctor, say? It means the professional body, not just 1 or 2 members of it. So you'd have to be showing that you were following professional guidelines. Advantage and risk. So in this case, the courts are looking at, for instance, were you in a situation where there's a very high risk of injury to a party? And if the higher the risk, the more you need to do to discharge your duty of care. In an emergency situation, you may be able to argue that the duty of care didn't arise, that the duty of care wasn't broken. So, for instance, if you were driving your pregnant wife to hospital and she was in labour as she went, then it would seem fair enough that, you may well take slightly more risks than you would in a normal situation. Also, vulnerability. So, actually, we owe a higher standard of care to someone who is especially vulnerable, and that could be children, for instance, or in this particular case, a worker who was blind in one eye, and he was working as a welder with a soldering iron, got a little bit of molten metal in his eye and damaged his eye. And the problem was this particular worker was already blind in one eye, so this damage meant that he was now completely blind. The court said that in that situation, the employer owed a higher duty of care to a worker because he was particularly vulnerable because of his already existing injuries. Now, I skipped over this little box here, res ipsa loquitur. This box is about a special rule that reverses the burden of proof. Remember I said the claimant had to show that he was owed a duty of care and that the duty of care was broken. But in this case, if you can bring your case within the facts of res ipsa loquitur, it's assumed that the duty of care was broken, and it's up to the defendant to show that that wasn't the case. So, what do we need to show? Well, we need to have a situation where the cause of damage isn't really known, but it's pretty definite that this damage couldn't have happened unless the defendant had demonstrated a lower standard of care. And the thing that caused the damage was under the management and control of the defendant. Now, if I tell you the situation when this arose, this is to do with a case that was brought against Tesco stores, and it was due to a lady going into the store and slipping on some spilt yoghurt. And the argument would be that she wouldn't normally have fallen over and injured herself, so there must have been something unsafe about the floor. The floor and the yoghurt were under the control of Tesco's, and therefore Tesco's were presumed to be liable unless they could prove otherwise. Okay, so res ipsa loquitur, it reverses the burden of proof. Now, the next thing that the claimant has to show is that they suffered loss as a result of the breach of the duty of care. So, the sort of loss that you can claim for here includes personal injury, damage to property, and also what we call consequential economic loss. So, for instance, property damage or loss of earnings in connection with this injury. So maybe taxi expenses to take you to the hospital to have your physio, the physio's fees, things like that. But not this concept of pure economic loss. So what does that mean? Well, the easiest way to understand that is to think about this case here, the Spartan steel alloys case. So in this case, the claimant was smelting a steel ingot. So it was actually in the machine at the time when the defendants chopped through a cable and cut off the electricity supply. So this caused quite a lot of damages, obviously to the ingot itself and the machinery that was being operated at the time. And also because the factory had to shut down, they lost production time. So the court looked at this and they said that it was fine to claim damages for the ingot itself, because that was damaged when the electricity was cut off. They could also claim the loss of profit on that particular ingot because the ingot itself was damaged. But they couldn't claim for loss of profits on a more general basis because the factory as a whole wasn't damaged. And therefore, that didn't get covered by this rule. Now, the final thing on these three tests is this idea of the but-for test. Now, in order to show that the harm that you suffered, the breach of the duty of care, actually caused you to suffer harm, what you have to do is look at the chain of events. And we can do this thing called the but-for test, where what we do is we look at the chain of events and decide if we remove the negligent act, would the outcome have been the same? Now, there's a very interesting case on this, which is about a gentleman who drank a cup of tea and then he was ill. So after being taken ill, he went to hospital and the hospital had a look at him and sent him home. They said, go back to bed, and if you're still poorly tomorrow, come back and see us again. Unfortunately, he then died. Now, it turned out that the cup of tea he had drunk contained arsenic. Now, if you think about the three tests we've just looked at, was the claimant owed a duty of care? Well, yes, because a hospital should have been able to foresee that if it acted negligently in not treating its patients properly, that those patients would have been injured, would have suffered harm as a result. So he was owed a duty of care. Was the duty of care broken? Well, it was, because the hospital didn't look at him properly. They didn't check his symptoms properly. He only saw a nurse and not a doctor, and he was sent home to suffer on his own. So the duty of care was definitely breached. However, the hospital managed to show to the court that even if they hadn't behaved negligently, so even if we took out this negligent step here, where they sent him home, the outcome would have been the same. The patient would still have died because he'd drunk arsenic, and there was nothing the hospital could have done about that. So, in this particular case, the claimant's claim failed because of the but-for test. He didn't die as a result of the hospital's negligence. He died because of something else that had happened before the hospital were negligent, and therefore the hospital couldn't be held responsible. So it's quite an interesting case, but we'll see more information about remoteness of damage in a later lecture. Okay, I'll see you later for the next section.